Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions tonight. Tonight, I have a good topic. Marriage based green cards are going to become more challenging, just like any other type of application process. And you really don't want to take it for granted. So I'm going to help you out tonight by just talking to you about some of the red flags you should be avoiding in the marriage based green card process so you can get to an approval instead and try to avoid. Thank you so much for the gifts and try to avoid things like request for evidence, notice of intent to deny, and even a denial. So let's go over some of the number one red flag, and I just released a video about this. Is the documents are insufficient, right? You may, from looking at your application, you may think, wow, you really gave them everything they wanted, right? Um, and I would say this: do not just go and check a box, right? So you look at the list of documents, or you find a list of suggested documents that you should be submitting, and you just start to go ahead and check off boxes, right? So I use the joint bank account, for example. So you go ahead and you say, okay, we need a joint bank account. Why don't we, you say this to your spouse, why don't we just go and create a bank account together? You go do that, and you just submit this bank statement, maybe one bank statement with an empty bank account that you put $20 in, and that's your evidence, right? And then the two of you don't usually do that. It's not usually your practice to have joint bank accounts. You do have married couples that don't have joint bank accounts, right? That they would rather not have joint bank accounts. But for the sake of checking the box off, you go and get a joint bank account, but you don't do anything with it. That's a red flag for immigration. And how can they tell that something is off? I'll explain why it's a red flag, right? Number one, they see a bank statement coming in just created right before you submitted your marriage based application with nothing in that bank account, right? And maybe you even drew out that $20 that you used to open the bank account, you drew that money out. So maybe you're in the negative, maybe you're at zero. They're going to look at that and say, well, any two people can open a bank account together. And obviously, they're not doing anything with this bank account. Is this just a setup to make it look as if they have a real marriage? That turns into a red flag. And you will probably either go walk into an ambush at your interview. So it's not going to be a friendly interview. They're going to approach your marriage with skepticism, or you might end up with a second interview because they weren't convinced at the original evidence you submitted. So, in other words, don't try to make your marriage what it's not, okay? Just to meet ideals. There are still ways to show how you're building a life together as a married couple, even if you don't have a joint bank account. So make sure that when you're submitting documents, these are not documents that you're just trying to use to check a box, that you're actually submitting meaningful documents that reflect the life that you and your spouse are living together. So, in the alternative, you don't believe in sharing a bank account. So, what do? Maybe instead you exchange money. So, you have to pay this bill. So, you Zelle each other. Maybe your spouse is in charge of paying the bill. So, you have to Zelle half of that money to your spouse. You Zelle that money, and then the spouse pays it. You can show the Zelle transactions, right? That's one way of showing that the both of you are working together to meet your expenses. The other is joint bills, right? And showing that you have the joint bills, utility bills, for example, these are necessary. necessary types of bills that you have to pay with the both of your names on it. So always make sure that you're not just being pretentious and just creating documents in order to appease the immigration, because that's going to do the complete opposite. The other red flag is you submit. So I used to hear this very often. People used to say things like, I submitted the application, I submitted my marriage certificate and pictures. Well, if you submit pictures alone without anything else, that's not enough evidence. They're not going to see this as sufficient to prove a bona fide marriage. So don't think that sending your pictures in is going to help. I like to say this. Sending pictures in is like cherry on top. For example, when we're in the interview, that's usually the last thing the officer looks at, okay, let me see the album that you have. And then they'll flip through the album, they'll ask a couple questions. Um, so always make sure that you're still submitting other evidence than pictures. Pictures is just a plus, but it's not going to make your case approvable just by submitting pictures. But here's the other red flag. It's obvious that the two of you spent one day taking pictures in different parks, different places, and then you use those one pictures, right? I know some of you couples, maybe one person, one of the two of you don't like to take pictures, but do not think that you're going to just orchestrate a photo shoot and then send in that the photos obviously showing you taking pictures on one whole day, and that's going to sell your marriage, right? Whenever you're presenting your marriage-based application with pictures, you have to show different times, different places, different people, different seasons, different holidays, different outfits, not just your wedding photos, right? They're not just asking for your wedding photos. They want to see that you're actually putting your lives out there as a married couple. And that means showing different days and different times that you're going to be, that you've been spending your life together. So make sure that you watch out for this, right? Be very thoughtful. Choose your pictures carefully. Make sure you're choosing a wide range of pictures to present. The other thing is going into the red flag. And I would say this red flag is something you have to keep in mind regarding your spouse. So if your spouse is a US citizen, especially a US citizen who who has never been outside of the country, maybe they have very little experience with immigration, they don't know what they're getting into, right? And they think, and you can tell by what they're saying to you, they think, let's get married, let's live our lives together. Once you get married, you'll get your papers, and that will be that, right? They may not understand that it's going to take more than just getting married, that you have to present a whole case, you have to be invested, you have to correspond with the immigration, you have to show up to an interview. So the red flag usually lies with the spouse, that they don't know what they're getting into. And by the time they find out what it takes, they're either backing out of the marriage based process, or they're not submitting the right documentation because they are not privy to what it takes. So make sure that before you go into this process, that you and your spouse are fully informed about the kind of commitment it takes. When I represent my clients, I don't just accept any clients in the marriage-based process. I have to speak to both clients. That's the spouses. I have to work with both of them. because it really takes a team effort. It is not just one person. So the one red flag to me, and this comes across in the documents, by the way, right? If the other spouse isn't participating, let me tell you how it's going to show. That spouse is not going to give you a lot of evidence to submit. So they're not going to work as hard to submit the documents that are needed to get an approval. So getting statements from their friends and their side of the family to support your marriage, to say yes, they have seen that your marriage is real. Maybe all the bills that are being paid, maybe it's in both of your names, but all the bills are being covered by you as the immigrant spouse and not the US citizen. Those are red flags, right? So you have to make sure that your spouse is fully participating, involved in the process, because if they stopped cooperating halfway through the process, then you're in trouble. But what I do say is, leading up to the red flag, that's whenever we're dealing with VAWA, I can tell you. So VAWA is where you are being mistreated by a US citizen or resident spouse, and you have to apply for the green card on your own. That also is a red flag that leads up to VAWA. So if after informing your spouse that their full cooperation is needed, that they need to make sure they're committed to the process to ensure that you get through, and they are not cooperative, they're not happy about the commitment it's going to take, that's usually a red flag, right? That you're going to be in trouble for the rest of your process. And it's going to show, but the officer is not going to think like I'm thinking, because I see it from the immigrant's perspective, because I represent clients who go through this. But the officer is not going to see it this way. The officer is going to see a US citizen spouse who is not fully invested in the process as potential fraudulent marriage, right? Because it's usually in these fraudulent marriage situations that the US citizen or the resident, for example, they're being paid, they're not fully cooperative with the process because they're not as invested. So the two of you have to make sure you're going in and um, you're prepared and fully informed about the process. Um, Now, these are what I would say, these are not necessarily red flags that lead to you, potentially more questions or investigation of fraud or denial, can lead to a denial. But this is an area of the marriage-based process and the family-based process that is often overlooked, and it is the need for a sponsor. So the affidavit of support is needed to complete this process. You will not be approved in a marriage-based process or a family-based process without an acceptable and approvable adjustment of affidavit of support. So affidavit of support, it basically states that the sponsor, the petitioner, is making enough money to support you as the immigrant spouse. There has to be sufficient evidence, right? Sufficient evidence that is attached to the affidavit of support. Tax returns, tax statements like W-2s, 1099s, about 6 months worth of pay stubs, the most recent pay stubs. If you own a business, show proof of ownership of the business and how much the business makes. You have to go through that, right? The affidavit showing, you can show all you want that your marriage is real. If that affidavit of support is not done properly, you will get a denial, right? And you will not get to the green card. In addition to that, we also have to look out for changes in the future. So this is why it's very urgent. I say it's urgent. Treat your marriage-based applications as if they're urgent, because we might be seeing something called the public charge rule coming back. The public charge rule under Trump 1.0 was it basically looked at the entire circumstances of the immigrant and their household as well as a sponsor. So they looked at credit, your credit score, loans, educational background, employment, medical history, age, whether you're retired or not. They looked at all of that, right? And then, based on the totality of the circumstances, they decided whether that anything in your record indicated that you are more likely to be a public charge, meaning dependent on public benefits. So, as you can see, it's not just right now, and that's probably going to be very limited. We are on limited borrowed time under this administration with this current affidavit of support process. But under this process, you show your paychecks, you show your taxes to be able to show that you meet the income requirements. Now, if you now under the new system, that will not be enough. That's not going to be enough. You're going to have to show they were running credit scores. I mean, it was like you were applying for a mortgage. You're right. They were, and that also makes the process uncertain, right? I can look at an affidavit of support, look at the documents, and I can just predict, okay, this is approved. This is going to be approved, no problem. Under the new system, if that new system comes, it's not law yet. They haven't even announced any changes, but I'm saying that that could be what's coming because they did it the last time and the courts allowed the Trump 1.0 to do it. It's just because Biden came in and just threw out the old affidavit of support system, so the public charge rule, brought in back the old one, that we don't have it anymore. But over the time that we're going to be seeing changes, we're probably going to be seeing that coming back. So under the new system, it's going to be very uncertain. If that system comes in, it's going to be very uncertain. It's really going to be based on the observations of the officer and basically like a pros and cons, right, situation. They're going to look at all the pros related to your background, household, age, employment history, education history, credit score, debt. They're going to look at things like that. And if they see more pros than cons, you're good. If they see more cons than pros, maybe, for example, if you're sponsoring a parent, and we can see where this is going to affect certain people, because if you're a US citizen sponsoring a parent, and then that parent is now retired, maybe that parent also has health issues that are expensive, and they have not been in the country yet, or they're even here, but they're not insured. Say because of the health issues, they have medical debt that has accrued over the years that they're maybe slowly paying off. And because of the medical debt, say the credit score has gone down, and reflects the delinquent, maybe the delinquent accounts related to the health issues, the medical records. That there is going to be a definite con, right? I mean, more cons than pros, right? Now they're using the age, say, okay, they're retired, so they're not going to be able to support themselves. They have medical debt, it's expensive, medical debt that is unlikely to be paid off because the parent can't work anymore, and they don't have good health insurance, but they have persistent medical issues that continue to add to the medical debt, right? You see how that can turn into a situation where one can be denied as a potential public charge because of a number of factors in their background that frankly are probably beyond their control. where you would think that somebody, a citizen who's petitioning for their parent, in order to stabilize the parent would be good enough. But in a circumstance like this, we can easily see where it could be used against the parent to deny the parent the green card and put them as a public charge. So that's just an example of the old public charge rule and why it would present uncertainty in the future. It would be hard to predict whether green card application is going to be approvable. So this is why I say treat your marriage-based cases, family-based cases with urgency. And, these are just a few of the red flags that I've listed. Now, the other is making sure that you are looking at your application, right? Make sure you know the information in your application. If somebody is completing your application, should be a lawyer, but if somebody else, even if a lawyer is filling out the application, make sure you know everything that is in there. Make sure that all the information is accurate, because that can be another red flag, and it can get ugly very fast if there's a mistake in address history. There's a mistake with employment history. If something is missing, if children that you have are not listed on the application, that can be a big red flag. So make sure when I am putting the final applications together for my clients, I have my clients review the applications very carefully and inform us about any changes any changes, corrections, concerns, and we work together to make sure that we finalize any kind of details that they spot and need changed. So make sure, and that is to avoid the red flag of going into the interview and not knowing what's in the application, right? Because you don't want to have that conversation with the officer trying to explain now why that is not there or that was there. It's just not a great situation to be in that moment. All right, so I talked about some of the red flags in the marriage-based process, and some of this is also helpful to family-based process and even other types of adjustment of status processes. So what I usually say is be thoughtful when you're putting your applications together. One, make sure you always get legal advice and representation. I can't state that enough now, how small things can get very big. So make sure that you get representation to be thoughtful about your applications. Don't just send documents in or even try to create documents and send them in because you just saw a list, and that's what it needs to be on there. Make sure it's authentic to your marriage. Make sure it is genuinely reflecting how your marriage is, how you're planning to build your life together. Now, one question I get often is, if we live apart, will that affect the application? I can tell you, yes, it will. That's why it's very important that you also tackle those issues during the application process so that the officers understand that the circumstances surrounding you living apart. Now, if you're outside of the US and your US citizen or resident spouse is sponsoring you to come into the country, that's a different matter. But if you both are married and you're living in different states, you definitely need to tackle that you need to tackle that head on, because one, when you go into the interview, they're going to ask for your IDs, and they're going to definitely compare your licenses and your address. And if you don't tackle why you live separately, if you are living separately, they're probably going to have a hard time swallowing that pill in the interview. So For example, if the both of you are going to school in separate states and that's why you plan to live together, but for now you need to finish your degree programs, or you're doing it for your career. Um, I have had clients who they have custody of their child, and so while they're trying to make the transition, they have to stay with their child or in one state until they can move with their child, because of custody issues. So make sure that you're mindful of the circumstances and that you do uh, tackle that. Make sure you have a plan on your explanations regarding living separately, because of all of that is definitely going to be at things that the officer is going to look out for. All right, so I'm going to answer a few questions and then head out. Do you think it is okay if I fly domestically with K1 visa and I-94 expired? So I can't tell you specifically whether that's okay. I would say if you do have your if authorized stays expired, you need to make sure you get legal advice about your rights, what kind of consequences can come as a result of that. I know now it's going to be a very you know risky time to be traveling. 2 years, green card holder and British passport. I want to travel 2 weeks facing. Is it okay? 2 year green card holder. So if you have a 2 year green card, my answer is you have the right to travel. But you do have the right to travel, but you need to understand the risk right now of traveling. And you have to understand if what's in your background can affect you coming back into the country. So if you have anything in your background that could interfere with them giving you permission to come back, you definitely want to know that before you leave. So just make sure you're getting personalized legal advice. Does it still make sense to go through the T visa? Of course, yes, absolutely. You qualify for an immigration benefit, go for it. I don't know if this question here is going towards the misconception that it doesn't exist. Uh, VAWA. So I just got a number of work permits and a 10-year green card without an interview just in the past 2 weeks. And that was VAWA. I'm getting bona fide determination letters. That is the letter that basically is like a lifeline to my clients. It offers them protection from removal while their case is going forward. And then it also gives them the ability to apply for their work permit while they're waiting. We're still getting those. Those are types of relief that are authorized under the statutes. These are not president made laws. These are congressional made laws that are still there, that the government is obligated to adjudicate, to process. So if you qualify for the T visa, yes. If you qualify for VAWA, go for it. If you qualify for marriage base, yes. If you qualify for family base, yes. Employment base, yes. It doesn't stop because of this administration, right? The wheels still have to keep turning, and you definitely want to get protection under these times that we are living in these times. You definitely want to have legal protections. Um, what if he is deployed? So it just depends on the length of deployment. Sometimes they can rearrange the interview to allow the spouse to be there. It just depends. My husband got his, and they may waive the interview, right? They haven't explicitly announced that they're not waiving interviews. So for a military member, they may still make that accommodation. My husband got his 2-year green card. He got a DUI. We have a divorce court date. What happens next? So right now, they are definitely going after people. So they are no, a DUI alone may not be a deportable offense. So it's important for him to get an immigration attorney because a DUI is usually not deportable. Um, Now, divorce, he has his 2-year, he needs to get to the 10-year. Divorce, he can get a waiver to get his 10-year based on the divorce as long as it's a bona fide marriage. But he definitely needs to see an attorney about the DUI because they are really trying to deport people just based on very minor offenses. And so he could be vulnerable to be detained, to face certain consequences. So it's important for us to evaluate the DUI. Was it his first DUI? Has he had multiple DUIs over the years? That's going to count towards our advice about whether he's deportable and what to expect in the process. And then we also can assist going from the 2-year to the 10-year. So that's what's to expect is, but he has to know what to do. He has to know what to do. So I know you're going through a divorce, but if you are also trying to figure out what he can do after the divorce, then it's time to definitely just tell him to give us a call so he can go from the 2-year to the 10-year on a waiver, on a divorce, what's called a divorce waiver, where he can go through that process without you. Most people, though, have to know that this is available to them. And unfortunately, it's very common for green card holders who have 2-year green cards to fall out of having proof of their status because they thought that they couldn't do it without their spouse and made the time pass. What's the priority date for I-601 waivers? So I-601 waivers don't have a priority date. You can look at the estimated processing times at the USCIS website. I would be worried if my country of birth is incorrect on my work permit. You definitely want to get any incorrect information corrected on the work permit, and that's going to take probably submitting another I-765 indicating you need a correction. 2-year green card holder, so I answered that. Where are you located? We're located in Delray Beach, Florida. We do represent clients in all 50 states and the globe. Police report says no weapon and held to floor while robber took money, argue false imprisonment for U visa. So definitely give us a call and let's talk to see what that case entails. You do still need a U certification for the U visa. Thanks so much for all the gifts. I appreciate it, K Car. Thanks so much. Can I travel if I got DUI with my green card? Before you do anything, you need to get legal advice, and you can definitely give us a call and then we can advise further. Definitely put your questions in the comments. Hi, I sponsored my, thank you so much for the gifts. I appreciate it. I sponsored my ex-wife, got approved 2019, and we got divorced in May 2020. Then I married my HU. I'm not sure what that is. So I don't see the rest of the question. I have overstayed B1 visa and approved VAWA, but I'm outside the USA. Do I need a waiver to enter the USA again? It depends on if you had, so if you overstayed less than 180 days, it's unlikely. However, if you have other things in your background that make you inadmissible, a waiver is going to be needed. So definitely give us a call, let's talk, and then we can decide the next steps. Can I travel if I got DUI with, so I answered that. Anything to do with criminal offenses, you need to talk to an attorney for sure, because that can lead to very severe consequences. So you don't want to be caught sleeping on that, or being in denial about the severity of the crime. If you get denied before you get your I-601, is the I-601 still pending? Yes. So the no, if you that could be a sign that the pending I-601 was denied, because usually the adjustment of status is based on the pending I-601. So you may get a denied I-601. Um, Two deportations. Can one get green card from marrying a citizen? It gets very complex from here. If you have two deportations, and usually two deportations, that sounds like re-entering and then deported again. So it would get to the complex level where we need to find out the specific facts to determine how you can apply for your green card, marrying a US citizen after two deportations. So definitely get in touch. I'm a divorced adult child of a US citizen. My mom wants to file for me. How long is the process? I'd say 5 to 7 years right now. Thanks so much for the love. I really appreciate it. We're in Florida, but we represent clients in all 50 states and the globe. So no matter where you are, we can definitely help you. And now what you can do is if you really would like to have a conversation with one of the attorneys here at ST Law Office, see what you qualify for and move forward ASAP, go ahead and you can go to the link in the profile and then give us a call. We have 24/7 answering line, and this is the entire team that's on board to answer the phone and to make sure that you are on the calendar to start talking to us about your needs. So go ahead and give us a call at any time, anytime. If you sit down and think about us 3 in the morning and you want to get started, give us a call, and then that's where it starts. Then we'll get back in touch with you and get started on a free initial evaluation. Okay. How long for USCIS to approve I-130? If you're the immediate relative of a US citizen, you could be looking at 9 to 12 months. However, if you fall into other categories, it can go to 2 years, 3 years. So it just depends. Okay. Hello there on Instagram, and then I'm gonna come to those of you on YouTube. So please hang tight. Hi there, Mary on YouTube. Hi there, Lydia. It's nice to see you. Lizeth, nice to see you. So I'm gonna come back to you, and then I'm gonna just come to Instagram. Can you go over the red flags in the marriage-based green card? So if you go to getting the green card, you can rewatch the live on YouTube. So the channel that's where all the lives are recorded and left there. So if you want to go and you want to see the lives replayed again, go ahead and subscribe to Getting the Green Card on YouTube, and you'll be able to go over those red flags. And yes, it is very, very useful. What are the processing times currently? So it depends on what you're applying for. I filed combo card last June and I haven't received a receipt notice. What can I do about it? Definitely you have to contact the USCIS directly. Let me see, when last June, yeah, that is a long time. Contact the USCIS directly. Let them know that you still haven't received your receipt notices, and they can track it to make sure it was filed, make sure they have it in their system, and they can resend it to you. Now, if you change addresses, you have to make sure you change your address as well online through the AR-11 form. Can I go the religious road? I'm currently in asylum, court proceedings, and out of status. So if you're referring to the R visa, that's for religious workers. It depends. It depends on a lot of things regarding your status and what the role entails, who wants to sponsor you. Get in touch with us and we can walk you through it. How long does it take to get a bona fide determination? So I would say 70 to 90 days to get the bona fide determination. What can someone do when the US spouse is no longer interested to proceed on the I-130 application? So I-130 is a petition the US citizen would file. So that is definitely a choice of the US citizen, right? It's the choice of both parties to decide whether they want to move forward or not. However, if a part of not going forward with the I-130 is they were mistreating you, they used it as a tool against you, they used your immigration status as a pawn, or they just mistreated you, right? Verbally, mentally, emotionally, then it means that you could qualify for VAWA based on the mistreatment. So there's nothing you can do with the I-130, but you can move from the I-130 process to the VAWA process. And that means that they no longer have the expectation that your spouse is going to be involved in the process, and they only you have control over your process to go through your process alone in a confidential process. So this is where you definitely give us a call. Let's talk and get started if you qualify. Let's see. If a person has, so I see my question isn't being answered. Make sure you put your questions in the comments and I'm going to scroll through and answer. So if you're still there, put those questions in the comments. If persons have a 5-year visa waiver, B1, B2, is it safe to travel on vacation as usual? So it's going to depend, so here's what I say. If you travel often and you say you just traveled into the US last month and you stayed for 6 months, then you're returning again to the US, that's a red flag. And sometimes they can pull you over and try to, search you, look through your phones to see if there's anything that indicates that you're coming to stay or work, stay permanently, or you come with the intention to work. That can snowball very quickly and cause somebody to be denied and turned around if they spot anything in your phone, or they just don't like your answer. They think you're still being suspicious. They will move to revoke and put you through expedited removal or request that you sign a voluntary form withdrawing your request to enter the country, right? Withdrawing your request for admission. So that can happen. I don't want to scare you, right? But what I do want to say is the risk factors are higher for some than others. We just heard about two, I believe, German tourists. So two guys they're traveling around the world, and the US was one of the stops. They came to the US, but guess what? They didn't book hotels. And because they didn't book the hotel rooms, the immigration turned them around and basically detained them, and then humiliated them, and then turned them around and sent them back out of the country because they said they didn't book hotels, so they didn't have any proof they were going to stay here. So where were they staying? Oh, they must have been coming to work. So it depends. You have to make sure that when you're coming in, think of make sure you keep in mind the risk factors, and try to minimize those risk factors as much as possible. If you've already traveled, then maybe give it some time before you travel again, right? If you've already traveled and stayed a lengthy time, um, if you have done anything like you've married a US citizen or a resident while being here, now you're coming to visit them, you definitely have to show that you continue to maintain ties like a job in your home country, because they're going to have questions about whether you plan to come to stay with your spouse or to overstay your visa. So, it's going to depend. I say a safe, pleasant trip is going to really depend on uh, background factors, risk factors, and you have to just be mindful of those. Okay, so go ahead, put your questions in the comments. Put it in the comments so I can see. Um, Okay, so talk about age differences where the woman is older, more than a decade than the male. This is a good red flag. Absolutely, this is a red flag. So, age differences is a major red flag, and this is where it's not to say you can't be approved. I've seen couples still be approved with a large age gap, but you definitely have to show why your marriage is bona fide. You have to shore up that evidence to make sure that that any evidence that you provide outweighs that red flag there of the age difference. Because some people, age is just a number, but you have to show it. This is where you definitely have to make sure you show it's a bona fide. So you have to work hard. Everybody has to work hard to show the bona fides, but you definitely have to make sure you're not stingy on the evidence there, on the bona fide. So living together, making sure you show how you're building your life together, through joint bills, things like that. Joint bills, joint property, estate planning, things like that. And financial commingling, once again, doesn't necessarily mean you have to have a bank account together, but it means that you can show in some way or the other that you are building a life together. And that includes financially. How are you doing it financially? I received a denial on my online account since last year, July. Up to this day, they cannot provide me with a denial notice, not even in my FOIA. Twice I've requested it, and twice it's not there. So this is definitely one of those unique situations where you need legal advice for us to understand why you're not getting that denial notice and what kind of case is it. I have a question, not in related to marriage based, I-45, but employment based. So I think I'm putting it together. So you have a employment based case that was denied, but you don't know why. So this is where it's important to get in touch with us and let's talk through the details. Maybe we can shed some light on it or assist you with figuring out a solution here. What does it mean when the USCIS portal says attend interview if necessary, completed while no interview attended? How long does it take for USCIS to make a decision on a marriage green card? So I don't know. It depends. I don't know what the facts are here. So we'd have to talk to you about your facts to understand why it says the interview is completed or what happened. Did you get a notice before? So we'll have to talk. So give us a call and let's talk if you're really concerned about it. All right. I'm a US, now I'm on YouTube, Facebook. Hi there. I'm a US citizen, and when I was working student during high school, I sold alcohol to a minor, but did hours in school and paid my dues. My ticket expunged. Should I worry about traveling? If you're a US citizen, you should not have anything to worry about. What I would say is, as a US citizen, even US citizens are being pulled aside and being scrutinized. So be ready for possible situations like this. Also, if you if you were not a citizen when this selling the alcohol to the minor happened, um, and then you became a citizen afterwards, my next concern would be, was it disclosed on the application? Whether it's expunged or not, it must be disclosed to immigration. So was it disclosed to immigration? If not, that raises concerns of potential fraud. And that they're saying they are looking at denaturalizing citizens where there is obviously fraud in getting citizenship. So they're saying they're going to amp up that movement as well. So I'd be a little concerned there, but this is where I leave it to you to give us a call for legal advice, to just, see, kind of get down to the facts and see whether it's something to worry about. My wife is a green card holder. She put in an I-130 for me, 17 months now. When check on it, she's 12 months. So the online system, it's just not dependable. So I don't watch it. I just go based on my experience and how long cases are taking based on my experience. So we work with students, but it depends on what your case is. So if you called, you did an evaluation, whether you're a student, if you did an evaluation, we look at how you can get residence here, how you can get your work permit here. And so it depends. We don't waste your time by evaluating you for solutions we can't help you with. We only focus on solutions we help our clients with that can help them to get protection, help them to get their work permit and their green card and residence here. So, that's where our initial evaluation comes in. Can I buy a house with an EAD? That is a question for a realtor or a mortgage broker. Can an asylee with DIY file for his spouse and get approval? It's possible if it was done properly, and if the case is approvable. So if you have doubts, you can always give us a call and let's talk. 30 months waiting for VAWA without green card. How long do I have to wait for the VAWA approval? So it can be 3 years. So 3 years is what I'm seeing from my clients. Can a pending asylum application that switched the adjustment of status through marriage with a U.S. citizen be detained during interview due to previous status? So it's rare that that's happening, right? They're not in the business of doing that to everybody, but where they are doing that is if they find any criminal issues that now cause you to be deportable, any past deportation orders, yes, can possibly result in detention at the interview. So you have to be very wary about what's in your background to make sure there's nothing in your background that's going to cause any issues at the interview. If I'm a Canadian citizen and came here to US married and non-green card holder, can I stay more than 6 months even if we didn't file yet? So I don't know what a non-green card holder is. Is it someone who doesn't have their papers at all? Because we usually say US citizen or green card holder. A non-green card holder to me is saying they have neither a green card or citizenship. So I would say here, No, you can't. Even if you were married to a US citizen, even if you overstayed, as long as there's no fraud involved in the overstaying, then you could apply for adjustment of status even with the overstay. But if when you're married to a green card holder, it's so important to maintain your status and to understand the priority date. Failure to understand the priority date, how that plays into when you can apply for the green card, and failure to maintain your status, you're basically, coming in on a like a visa waiver as a Canadian. It means that whole thing will be sabotaged, right? If you don't get it right. So get legal advice for sure. And before you make any decisions, get legal advice so you fully understand and fully are informed about the consequences. Can my wife visit me in the U.S. while we're waiting for a schedule for her to schedule for immigration interview? Be very careful because you're waiting. Now your wife coming in, they can say she has immigrant intent, right? Because she's waiting for an interview. So, in cases like this, I usually say try to minimize travel. Just wait for your interview, get through the interview, and here's why. If you come in on your spouse is coming in trying to get in to visit, but they take it another way and they say, well, it looks like you want to come and stay permanently, so we're going to turn you back around. That can actually turn into expedited removal, and she can actually have a 5-year bar. So now she needs a waiver to come back into the country after doing her immigration interview, or she finds that out at the interview. To avoid complications, you definitely have to think about that risk of coming in and right at the border, they uh, they turn her around and then create issues for her application in the future. Hi there, Mary. If you are not under parole program and apply for asylum, did the pause affect you from getting work permit? No, the pause does not affect you from getting the work permit. My VAWA AP denied due to removal proceeding. Now I got admin close on asylum. Can I get AP now? Um, so one, be very careful about traveling. You had the removal. Yes, it's admin close, but you want to take that risk if traveling on an advance parole? And now if the proceedings is no longer an issue, then you can go for AP again. But keep in mind, I'm not your attorney. I can't give you personalized legal advice. But if the removal proceeding is not an issue, then you can always try again. My VAWA, let's see, so I answered that. When you apply for I-130 and you apply after for I-485, when is the final action date? So look at the National Visa Bulletin and you'll be able to see the final action date. It's based on the date, your priority date, and it's based on the category you're in. So you'd have to look at that. After I submit my documents for my 10 years, my husband give me I think a divorce document. Get in touch with us. You can still apply to get your 10-year based on the divorce, but we have to look at your facts. One thing is very important is even if you're filing for a waiver based on divorce, you must show that your marriage was real, even if it didn't work out. As granted asylum, congrats, and I have a travel document, but I have not applied for asylum green card. Can I travel? Traveling, keep in mind that I definitely cannot tell people to travel. I would say right now is not a great time to travel. You want to be aware of what the potential risks are. And while we are seeing a pattern we still have not settled properly into this administration to be confident about certain risk factors. So I would say if you have a travel document, you have a green card, these are, especially if you're a green card holder, you have a right to travel. Just make sure you have the right documentation. But I also say this, you have to be don't go travel blindly. Understand what's in your background, understand whether that raises a risk to you before you take that trip. Okay. Because yes, I definitely don't want your lives to be ruled by fear, but I do want you to understand the risk so you can empower yourself and you can know when to make a move and when not to make a move. So that's what I would say about that. Can I process my N400 online? Yes, you can apply online. And actually, I prefer because I find that the cases I filed online have moved very fast with citizenship. Is USAID still processing green cards for refugees? Yes, but they paused it. So pausing it means that they've paused it to go backwards to review applications for fraud. So it's going to take a longer time to get to the green card, unfortunately, but they haven't stopped it completely. Now, it's important to know that if you're going from a 2-year green card to a 10-year green card, that you can apply for your 10-year green card, even if you're given divorce papers, even if you're separated from your spouse, even if you are divorced, your divorce has been finalized, you can still move forward with this, because if you don't, you're going to lose your status, and you have every right to move forward with your from your 2-year to 10-year, as long as you can show your marriage was real, or you can show mistreatment, or you can show extreme hardship if you have to go back to your country. Is this a taped conversation? Go to Getting the Green Card. You can subscribe there and you'll be able to catch all the past lives. So everything that you see going on here, you'll be able to watch it on YouTube at any time. So go subscribe there. And with that, I'm going to go ahead and head out so I can get ready for bed and get ready for another busy day tomorrow. But here's the deal. Make sure you like, subscribe, hit the notification bell, follow. That's how I can help spread the word, and you can help me to spread the word that I'm here. I'm giving valuable information. So go ahead and do that. And it also helps you to know when I go live, so you can hop on. So you get notification I'm live. If you're available, you can hop on with me, and then you can ask your questions and I'll give you updates. There's a lot going on in immigration. So we are now seeing US citizens being detained. So I do release a newsletter every week. So if you go click on the link in the bio, in the description of the video, you'll see Linktree, and the Linktree has where you can subscribe for the newsletter. Go ahead and do that, because I release a newsletter every week about major changes. So surely we're gonna be discussing about the detention of US citizens. So far, two. They released, the two of them they did release. One of them was detained for 10 days. The other was detained for about a day. There was a very big uproar, and they released him on the same day or maybe the next day after he was arrested. But it shows that there is an escalation here, and they really don't care who they're picking up to detain. Everybody's sort of just being dragnetted into this operation, and then if they're lucky, they get released. Now, here's a concerning part, is that Are there US citizens who can't speak for themselves, who may be going through mental health situations, who don't have their papers on them, who have no support system to get papers? Are those people being caught up in this and being detained? Is that could that? I mean, it shows that it could happen, and this is why it's so concerning, because not only are immigrants targeted, but certain US citizens who look a certain way are also being targeted as well. So I will definitely leave that discussion for the newsletter or for another time, but that's just an update on my end. So, oh, well, here's some good news. So, U.S. Supreme Court put a hold on the deportations. So, under the Aliens Enemies Act, or the Alien Enemies Act. So, this administration cannot deport immigrants to El Salvador under the Alien Enemies Act right now. And we are also seeing an escalation in court regarding the administration disobeying court orders. And Judge Boasberg is one of the judges that's now looking at potential criminal contempt because of that. So we are seeing an escalation here between the executive branch, which is this administration, and the judicial branch. These are two different branches of government that have the authority to check each other. So the judicial branch is now checking the power of the executive branch, and the executive branch is not yielding. That's very rare that that happens. So we'll have to see. But really and truly, I believe it's the courts that are standing between this administration and um, basically getting rid of our rights under the Constitution. So it's so important that the court holds steady and is consistent about the message to this administration that they must follow the Constitution. And in May, they are going to also hear about the end of birthright citizenship executive order that the administration did. So a lot going on. There's a lot going on, and I'll keep you posted. All right. Have a good night, everybody, and let's be hopeful. Let's have faith. We are a safe space. Give us a call. Let's talk about your options. Let's evaluate your background, see what options are available, and get started. That's going to be very important. Whether it's marriage-based, family-based, T visas, VAWAs, we need to hear what your circumstances are, and then we can decide what option is best for you. Have a great night. I'll talk to you tomorrow. Bye-bye.